Good morning. I hereby call to order this 14th meeting of the Pennsylvania Public Utility Commission for the year 2016 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. First matter on this morning's agenda is the approval of the minutes for July 21st, 2016, and I will look to Commissioner Howson as the editor.
Thank you, Madam Chair. I've reviewed the minutes of the July 21st public meeting and recommend that they be approved as submitted here this morning.
There's a motion to approve the July 21st, 2016 minutes. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion, amendments to the minutes? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Now I will call on Cheryl Walker-Davis, our Director of the Office of Special Assistance, to lead us through today's agenda.
Thank you, Madam Chairman. Good morning. Good morning, Commissioners.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Bureau of Administration. On page 1 of the public meeting agenda, there are several items with regard to general assessments to fund the operations of various entities: the Office of Small Business Advocate, the Office of Consumer Advocate, the Public Utility Commission, as well as a general assessment on pipeline operators for the Registry of Pipeline Operators and certain enforcement activity. It is recommended on behalf of the Bureau of Administration that the Commission adopt these recommendations.
Do I have a motion to adopt staff recommendations?
So moved.
Do I have a second? Second. Motion by Commissioner Powelson, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And on page 2 of the public meeting agenda, on behalf of the Bureau of Administration, it is recommended that the Commission adopt the recommendation with regard to the general assessment upon electric generation suppliers and natural gas suppliers to fund their operations.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And I would clarify that is to fund the Commission's oversight of their operations. Turning now to matters on behalf of the Bureau of Audits, in omnibus fashion, it is recommended that the Commission adopt the recommendations on page 3 with regard to releasing various audit reports pertaining to the Metropolitan Edison Company, Pennsylvania Electric Company, Pennsylvania Power Company, and West Penn Power Company Energy Efficiency and Conservation Plan reconciliations.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing with recommendations on behalf of the Bureau of Audits, on page 4 of the public meeting agenda, it is recommended that the Commission adopt the recommendation to release the Management Efficiency Investigation Report, as well as the company's implementation plan with regard to Aqua Pennsylvania Inc.'s operations.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion on the recommendation or on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 5 of the public meeting agenda and matters presented on behalf of National Fuel Gas Distribution Corporation, it is recommended on behalf of the Office of Competitive Market Oversight that the Commission adopt the recommendation to implement procedures to facilitate natural gas supplier access to customer account information when that information is not available from the customer or eligible customer list.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Powelson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Office of Special Assistance with regard to the complaint proceeding of Core Communications, Inc. versus XO Communication Services, Inc. There is the motion, your motion, Madam Chairman, as well as the statements of Commissioner Powelson, Commissioner Coleman, and Commissioner Sweet.
I will turn this over to Vice Chairman Place to preside over this matter.
Thank you, Chairman. I would like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I ask that my motion be spread upon the record, and I will read a condensed version for you. Today's decision resolves a proceeding which has been underway since 2009 when Core Communications filed a formal complaint about XO Communications disputing how much XO should pay Core for telephonic traffic. The traffic is dial-up internet traffic and other traffic that does not have the information needed to bill for it. The parties are competitive local exchange carriers. Core's business is largely dial-up traffic, but they are now doing some voice. XO's business is mostly local and long-distance voice service. The dispute centers on payments for telephone traffic and 2 carrier identification codes. The 5119 carrier identification code is also dial-up traffic. It should be paid at the federally set cap of 0007, even though some think we should set a higher rate for some of that traffic. I disagree. A rate that exceeds the federal cap invites federal preemption. The 5607 carrier identification code is slightly more complex. Most of the traffic is also dial-up traffic. It should also be paid at the 0007 rate. But there is other traffic for which Core never got the information needed to bill XO. This traffic should be billed at Core's interstate rate, just like Core did in the past. This resolution encourages carriers to settle these kinds of disputes compared to having XO pay 0007 for all traffic, even if the information Core needs to bill for some of it is not there through no fault of Core. I also think a statutory interest rate of 6% applied retrospectively is appropriate. This result encourages carriers to resolve these disputes while recognizing the time value of money. Therefore, I move that, 1, the minute of use rate for all dial-up traffic in carrier identification code 5119 during February 2010 to April 2011, for that time period, be set at 0007, including the 180,858 non-local dial-up minutes. Number 2, the minute of use rate for all dial-up traffic in carrier identification code 5607 during the time period of February 2010 through April 2011 be set at the 0007 minute of use rate, excluding the 337,021 minutes that are not dial-up traffic. Number 3, that the 337,021 minutes that are not dial-up traffic and which lack calling party numbers needed to be billed properly for that traffic will be set at Core's interstate rate. Number 4, the traffic arising in April of 2011 and going forward shall be set based on this decision at rates that are also consistent with the FCC's transformation order. Number 5, Core be authorized to collect interest at the rate of 6%, that's simple interest, beginning from the date that Core invoiced XO for the February 2010 through April 2011 traffic up through the date Core issues a revised invoice for XO, or to XO. Number 6, Core issue a revised invoice to XO no later than 30 days after entry of this opinion and order. Number 7, XO pay the revised invoice within 30 days of receipt. And 8, the Office of Special Assistance prepares an opinion and order consistent with this motion.
Thank you. Is there a second?
I'll second the motion.
Seconded by Commissioner Sweet. For statements, we have Commissioner Coleman.
Thank you, Vice Chairman Place, and I would ask that my written statement be entered into the record as though I read it in its entirety. As the chairman has indicated, this is a intercarrier compensation dispute between two CLECs and the determination of how they should be compensated. For the reasons set forth in the written statement, I apply a uniform 0007 per minute for use compensation rate for all traffic at issue in this proceeding. This includes local ISP traffic, non-local ISP traffic, and ISP traffic where the jurisdiction is not clear. My main disagreement with the motion concerns the rate that we should apply to the 337,000 minutes of ISP traffic where the jurisdiction is not clear. I do not agree with the proposal in the motion to apply interstate access rates to this traffic. Instead, I believe CORE should be compensated at the cap 0007 MOU rate for this traffic. This rate approach reflects the long-standing commission policy that carriers are entitled to be compensated for the use of their networks and is a compromise between the competing arguments that CORE should receive no compensation for the traffic on one hand versus that it should receive access rates on the other. This rate approach also resolves the jurisdictional ambiguities surrounding this traffic. Under this approach, all the traffic at issue in this case would be compensated at a uniform 0007 MOU rate. With the uniform rate, the lack of a calling party number with the traffic and the distinction between local and non-local traffic becomes irrelevant for compensation purposes. Therefore, I will vote no on this motion. Thank you, Vice Chairman.
Thank you. Commissioner Powell?
Thank you, Vice Chairman. I'd like to first fully associate myself with Commissioner Coleman's statement as he's identified the proper result in this case. The use of 0007 per minute for all traffic sent by CORE by XO is a fair result that is consistent with the distinctive compensation policies carved out by the Federal Communications Commission, specifically for dial-up internet connection that CORE offers. The lack of calling party numbers, CPN, on some portion of calls delivered to the terminating carrier is an industry-wide problem, as we know. It makes billing difficult, even in some cases impossible. This phenomenon is known in the industry as phantom traffic. It essentially renders some portion, usually less than 10%, of a bill uncollectible. All carriers have this problem. It's not unique to the Pennsylvania marketplace. The FCC's rule directs all originating carriers to populate their calls with CPN information and all intermediate carriers to pass data unaltered to subsequent providers in the calling path. This commission has no rules on this topic and has never previously reviewed this subject matter. There are numerous fundamental problems with simply presuming that interstate access rates should apply in this particular case where the CPN is missing. First, there is no record of why CPN is missing. CORE, the party with the burden of proof, undertook no investigation of this absence. It may be XO who is at fault. It may be Verizon as a tandem provider. It may even be CORE itself. If it is not shown to be XO, then how can we penalize XO? The second point I'll mention here this morning is XO has no ability to solve the industry problem of phantom traffic. We do not provide XO with any tools here this morning to address this industry-wide problem that no jurisdiction here in the U.S. has been able to solve. We are simply penalizing XO to the financial advantage of CORE. Third point I'll mention here this morning is there's no basis for the Commission to endorse CORE's uninformed presumption that the call must be tolling based. Such conjecture is arbitrary and simply designed by CORE to take advantage of the lack of information in order to bill the highest possible rate. The fourth point I'll make here is it makes no sense to presume that callers from outside of state are calling a CORE telephone number in the Commonwealth of Pennsylvania to connect to the internet. The only circumstance under which this interstate access charge would apply, and by the way, the use of interstate rates simply emphasizes the unfair punitive nature of this remedy. Fifth, this penalty approach is a major shift in intercarrier compensation that the Commission announces in the context of a two-carrier complaint case that has a severely underdeveloped record here this morning. Penalizing XO for the lack of CPN data was not an issue below. The proper solution would be to seek industry input and a full vetting of the problem and discuss potential solutions. To do otherwise is uninformed, arbitrary, and violates due process for all parties. The sixth point I'll mention here this morning is that the traffic at issue dates as far back to calendar year 2005. And to apply the new originating carrier suffers rule to calls made during the last decade is an egregious case of retroactive rate setting and is fundamentally unfair. The seventh point here this morning is we are departing from our own precedent and that of the FCC. In November of 2011, the FCC took complete control over intercarrier access rates and rules, including interstate access. Imposing a penalty rate at this late stage to solve the lack of CPN departs from those rules without acknowledging, let alone justifying it. The eighth point here this morning is we are incentivizing arbitrage. Let me repeat that. We're incentivizing a business practice that yields an arbitrage. The FCC, after careful consideration of the matter, declined to impose penalty rates or fines for this very reason. The ninth point here this morning is we are simply creating a more inter-carrier litigation, as terminating carriers will claim foul based upon this unprecedented ruling and seek the penalty rate. Other carriers, as well as CORE, can now take advantage under our 4-year look-back refund statute and seek refunds based upon this newly announced rule. The last point here this morning is intercarrier issues have largely been resolved by the Federal Communications Commission. And by the end of this decade, the FCC glide path to zero will have been achieved, and there will be no intercarrier compensation to dispute across the 50-state jurisdictions. Our only intercarrier disputes in the last 3 years, for the record, have involved CORE versus CenturyLink, CORE versus Windstream, CORE versus AT&T, CORE versus XO, and CORE versus Verizon. You follow the path here. The announcement of major rule change at this late in the game largely returns us to an era of intercarrier controversy that the FCC decided to end by reforming such rates. So in conclusion here this morning, the telephone industry should be aware that the Commission has now changed the compensation rules retroactively without any record or full consideration of all the parties involved. You are now subject to potential refund claims based upon something that is an industry problem, not one of your own making. For these reasons, I support Commissioner Coleman's outcome. Uniform application of 0007 rate precludes arbitrage, renders the lack of CPM irrelevant, and is easily billed for prior periods. For these reasons, Madam Chair, I respectfully disagree with the motion. Thank you.
Thank you. Commissioner Sweet?
Oh, thank you. I can assure you I don't have a 10-point statement to make at this point on this subject. My statement is just very simple. There will be a number of these where various items on our agenda were the subject of consideration and advice by staff, by individuals whom I've now employed as staff. On these particular items, I did not receive any input, advice, had no discussion with them on those matters. And so it's really a way of making sure to disclose that there was no such discussion. And I would ask the Secretary to place the statement on the record, and there'll be one or two more of these that I will just ask at that time that they be placed on the record. Thank you.
Thank you. Any further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed?
No.
No.
The motion carries 3-2 with dissents from Commissioner Coleman and Commissioner Powelson. Chairman, the gavel is yours.
Thank you very much.
Continuing with the presentation of agenda items on behalf of the Office of Special Assistance, it is recommended that the Commission adopt the staff recommendation in the proceeding involving the petition for reconsideration of Uber Technologies and the proceeding involving the Commission's Bureau of Investigation and Enforcement versus Uber, noting your statement, Madam Chairman, as well as the statements of Commissioners Powelson and Sweet.
Do I have a motion to adopt staff recommendations?
So moved.
Sorry, do I have a second?
Second?
Motion by Vice Chairman Place, and second by Commissioner Coleman. Under discussion, I would recognize Commissioner Sweet.
Thank you. Had I been a Public Utility Commissioner when this whole matter was first adjudicated through an opinion and an order on May 10th, 2016, my approach to this case might have varied from the conclusion reached by the majority in that 3-2 vote at that time. However, the assignment today is different. The issue before us is to determine whether a reconsideration is merited based on the legal standards applicable to such a request. There has been no change of law or any compelling new evidence unearthed that was unavailable during this entire proceeding. While the May 2016 order may seem harsh to some and even unwise public policy to others, the applicable legal standards for the imposition of a fine and civil penalty were met. No legal or factual error was made by the Commission's action, in my opinion, and after review of the record. Since there is no clear legal argument compelling a reconsideration, I must vote to deny the request and support the conclusion set forth in the proposed order on pages 76 and 77. As an aside, the entire legal and regulatory framework under which Uber, Lyft, and others are operating, both in Philadelphia and throughout the state, still requires the focused attention of the Pennsylvania General Assembly. While the law must be obeyed, and that's highlighted by the May 2016 case, it also must be modernized to address new realities. Otherwise, we'll again be in this same room trying to figure out how to put the proverbial square peg in a round hole. Thank you.
Thank you, Commissioner Sweet. Commissioner Powelson.
Thank you, Madam Chair. Before the commission here this morning is the petition for rehearing and reconsideration by Uber Technologies to the commission for the May 10th order in this proceeding. In that order, the commission determined that Uber must pay an $11 million civil penalty operating as a transportation network company without proper commission authority. As we all know, I issued a dissenting statement in that proceeding arguing that the fine was excessive. Today, I'd like to reiterate my dissenting position that the penalty imposed in this proceeding is inappropriate and inconsistent with commission precedent. As I previously pointed out, the fine in this case is much higher than in other commission proceedings where there have been fatalities, serious bodily injury, significant property damage and property loss, or patterns of unsafe business practices that jeopardize the public safety. Assessing an $11 million fine in a situation where no one was injured, there was very little evidence of actual harm, and abuse of, obviously, the commission is an abuse of the commission's discretion. As Uber asserted in its petition, the harshness of the penalty vastly exceeds the gravity of the offense in this particular case. Along those lines, I make reference to a letter that Governor Tom Wolf, Pittsburgh Mayor Bill Peduto, and Allegheny County Executive Rich Fitzgerald basically sent to us. It's entered into the record, recognizing a concern that the excessive fine in this matter sends the wrong message about the business climate for innovation in this Commonwealth. The letter goes on to emphasize, and I actually agree, and I'm a Republican, so I agree with Governor Wolf that Uber should be penalized, but we also agree that in no way minimizing the illegal behavior that Uber engaged in. Any motor carrier that operates in Pennsylvania without proper authority from the commission is committing a serious offense. We all recognize that, and I also commend my colleagues who stressed this whole issue of public safety. However, it's important that the penalties we assess are not only commensurate with commission precedent, but also commensurate with the offense or the violations that occurred. The governor's letter clearly recognizes this in stating that Uber should be treated like any other company and the regulation of its business should be in line with that applied to all other businesses here in the Commonwealth. Additionally, I'd like to point out that no one was physically harmed, and customers who used the service did so voluntarily. Moreover, it cannot be overlooked here this morning that providing an alternative to traditional call-on-demand service, Uber was supplying a much-needed benefit to customers. And yet, the Commission has chosen to assess the highest fine in the history of the Commission in this proceeding, a fine that breaks down to be almost $60,000 per day. Now compare this to the amount of the Lyft fine for the same behavior over a similar time period, which only translated to approximately $1,000 a day. Clearly an inequity in the treatment of both entities. It is clear here this morning that the fine imposed in this matter is excessive and is also grossly disproportionate to the profits received by Uber during the time period of the uncertificated service. In its petition for reconsideration, Uber asserts that the penalty is more than 110 times greater than its net revenues in Pennsylvania during the time period when the cease and desist order was in effect. It is unfortunate that the evidence of Uber's profits and revenues during that time was uncertificated and is not on the record, because if it had been, it would have been supported a significantly lower fine than I asserted in my April 21st dissenting statement. And Madam Chairman, respectfully, for those reasons, I'll be dissenting here this morning.
Thank you, Commissioner Powelson. I will be reading a joint statement on behalf of Vice Chairman Place and myself. And we can actually agree with Commissioner Powelson when we say that the PUC's #1 priority with regard to motor carriers is to hire is public safety. Public safety to us is key. By operating without proper authority, this commission was unable to verify critical safety standards such as Uber's drivers' backgrounds, vehicle integrity, and the validity of insurance. When a regulated entity is given notice that it is violating the law, giving numerous opportunities to comply with the law, and ignores those notices, it does so to its own detriment. We do not take lightly the fact that the civil penalty imposed in this case is the largest in this commission's history. And let me emphasize that again. We do not take this lightly. However, the reason the penalty is so large is because we were faced with an unprecedented number of violations committed by Uber. In the instant petition, Uber argues that the civil penalty imposed is inconsistent with penalties imposed on other jurisdictional entities. In fact, the $7 per violation imposed for Uber's actions that occurred prior to our cease and desist orders are some of the smallest per violation amounts we have ever imposed. The $250 per violation amount imposed for the period during which Uber continued to operate after we issued our cease and desist orders are consistent with our treatment of other carriers found violating the Public Utility Code and the Commission's regulations. We reiterate and emphasize that this Commission supports the innovative TNC business model. TNCs provide a much-needed service that the traveling public has embraced, and the TNC companies contribute to the economic growth of the Commonwealth. This is why we granted Uber and its competitors certificates of temporary authority. It is also why we continue to work with the General Assembly as it drafts legislation that will allow TNCs to operate under permanent certificates of public convenience. We are voting to deny Uber's petition for reconsideration because Uber has not met the standard established in the Do-It case, which requires a petitioner to raise new and novel arguments not previously heard by the Commission. The crux of Uber's petition is a reiteration of issues considered at the complaint and exception stages of the proceeding and does not persuade us that the public interest would be served by modifying the civil penalty imposed upon the company. Are there any other comments for discussion?
Madam Chairman, I'd like to associate myself with your joint statement this morning. I'd also like to go back to Commissioner Sweet's comment. I think he really set it up well this morning. Our intent was not to retry this case here this morning and to go back in time with all of the issues that we have discussed publicly here, but I can see, unfortunately, that's where we are this morning. Although I do agree with Commissioner Sweet, I don't see anything in this petition for reconsideration that would warrant us to change course from where we have been. I also want to thank all of the commission staff that have spent an inordinate amount of time. This has been a huge distraction for this organization, not only with this proceeding, but with many other aspects of this that have taken an inordinate amount of time and energy out of this commission to address this matter. I guess I would describe this case really as unprecedented, and it's unprecedented in so many different ways. And I think that really spells out why we are where we are today in this particular proceeding. It's unprecedented from the very beginning when company officials came and met with our Law Bureau and were advised that they needed to be certificated before they started operation. And they said, we don't care what you have to say about that. We're going to start operation anyway. It was unprecedented when our Bureau of Investigation and Enforcement conducted a sting operation in the city of Pittsburgh where they were operating illegally. And we cited about a dozen drivers between two companies at the time that were operating illegally, both Lyft and Uber. And the response from the company was, we'll pay your fine, continue to operate illegally. We had administrative law judges that took up the matter and issued a cease and desist order. And the company said, we don't acknowledge your authority on this matter, and we're going to continue to operate. It was unprecedented when it came before this commission, when the administrative law judge order came before this commission, and we affirmed 5-0 the administrative law judge's cease and desist order. And the company's response was, we still don't recognize this commission. We do not recognize your authority on this matter. So it is unprecedented in so many different ways. As the chairman has indicated, it is unprecedented in the number of violations. More than 120,000 violations. 120,000 violations. We've never seen anything like that in this organization. Nothing even close. Now, it's been mentioned that we compared to other cases, and quite frankly, I think that's disappointing. That as I've indicated, this is so unprecedented in so many different ways. But if we choose to compare to their competitor, Lyft, who realized the error of the way, and they chose to provide information that this commission had asked for, where Uber decided not to. And so Lyft went on a very different path of settlement that resulted in a very different outcome. This company chose not to do that and to continue to defy the commission for the information that we're now talking about this morning, that we had asked for and was not provided and was not part of the record. So I think we need to be clear about that piece, and that there was an opportunity for for Uber to take the path of their competitor, and they chose not to do so. They chose to take this path. So while we have tried to put them on the path of compliance on at least a dozen different opportunities, they have chosen not to do so. When we look at some of the cases where there have been penalties, in many of these cases, they were not willful acts of violation. In a gas explosion case that was mentioned in the record, this was not a willful act on the part of the regulated entity. This was a truly unfortunate event that resulted in fatalities. And the commission's response was to fine them the very maximum amount that we were provided to apply in those situations. So let's be clear about the amount of the penalty. It was the maximum amount. There's also an electric supplier that was mentioned. Again, if we apply the same metrics to the customers that were affected by that supplier who chose to try to recover costs from a polar vortex wrongfully, and the commission called them out in a multi-million-dollar settlement or multi-million-dollar decision. If we applied that same metric in what that fine was per customer per violation to this case, we would be talking about a much, much larger number. The final point I will make is that if we go back to look at the record and what the recommendation was from the administrative law judge, which was nearly $50 million, $50 million. What we're talking about this morning is something much, much lower. And again, I think the important point here is to realize the number of violations that we're talking about, which is truly unprecedented and has put this commission in a very difficult position. So again, I want to thank the team of the commission. I want to thank my colleagues this morning, and I will be voting yes on this recommendation. Thank you, Madam Chair.
Thank you, Commissioner Coleman. Any further discussion? Hearing none. All those in favor of the staff recommendation say aye.
Aye.
Any opposed?
I'll be voting to oppose.
The motion passes 4-1, noting the dissent of Commissioner Powson.
Continuing with the presentation of agenda items on behalf of the Office of Special Assistance, now on page 7 of the public meeting agenda. With regard to the first item, the formal complaint proceeding involving Beth Trivial-Peace versus Pico Energy Company, there is the motion of Commissioner Sweet as well as your statement, Madam Chairman.
Thank you. Do I have a motion to call up this matter for consideration?
So moved. Second.
Motion by Vice Chairman Place, second by Commissioner Powson. Under discussion, I will call under Commissioner Sweet for his motion.
Thank you. Let me summarize what's really a rather lengthy motion, but would indicate and request that the full motion be submitted for the record as though I'd read it in its entirety. In summarizing, let me just begin by saying the Commission has before it the disposition of exceptions on Pico Energy Company and reply exceptions of the complainant in the above captioned case to an additional decision which assesses a $6,000 civil penalty on Pico. This case is troubling and frustrating for me because it's not about adjudicating the customer's bill. It's really not about the $6,000 because the penalty, if assessed, won't really help the complainant. Really, the issue is whether Pico's behavior, in this case, violates the standards which would justify, so violated the standards that it would justify the imposition of a civil penalty. And in my opinion, it does not. The facts here, and I will not belabor them, but they will be placed upon the record, are sad and are all too often the case. We're confronted with a story of poverty, of illness, and also just plain bad luck. The complainant moved 5 times, and each time she moved, an ever-escalating bill from Pico followed her. The final amount that was that had accumulated was on nearly $13,000. And when she opened her 5th account, this accumulation from 4 previous accounts followed her. The complainant filed a formal complaint and was represented by counsel. From the record, it's clear Pico had extended multiple payment arrangements to the complainant. The complainant had been awarded a LIHEAP grant, and Pico had placed her in its CAP program when she lived in the 2nd of these 5 addresses. There were 2 different BC Bureau of Consumer Services, BCS cases opened during this period of time, and there were attempts by both BCS and by Pico to resolve this matter in some way. But the frank reality of this is that this is one person among hundreds of thousands of people in Pennsylvania who just could not afford or was not able to pay this bill, which she allowed and circumstances allowed to accumulate. I agree with the majority of the recommended dispositions of the exceptions and reply exceptions in this matter, except that I don't believe the reversal of the administrative law judge's findings go far enough. From my reading and review of the record and applicable rules of law, PICO's behavior in this case, while not perfect, was not so egregious as to support a civil penalty. Again, I would reiterate that even if we assess a civil penalty here, it's not going to solve the complainant's problem. And that's my real frustration in this process and how the proceeding evolves and comes before us. Again, I would suggest that PICO's behavior was not so bad as to justify the imposition of any civil penalty. And quite frankly, I don't think quibbling over whether it's a few hundred or a few $1,000s makes a whole lot of difference here. I think the threshold is the behavior so egregious that a civil penalty should be imposed? And my view is that it should not. Therefore, I move that the PICO exceptions are granted consistent with this motion and that the OSA prepare an opinion and order consistent with the motion. Thank you, Madam Chair.
Thank you, Commissioner Sweet. We have a motion by Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Coleman. Under discussion, I do have a statement that I just want to submit for the record, but I will note that while I will vote to support the resolution of this matter, I do believe that a nominal civil penalty of $500 would have been merited in this case. If there's no further discussion on the motion, all those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Vice Chairman Place. On the motion, on the matter as amended by the motion, any further discussion? If none, all those in favor on the matter as amended by the motion of Commissioner Sweet, say aye.
Aye.
Any opposed?
Opposed?
The matter passes 4-1, noting the dissent of Vice Chairman Place.
And now continuing with the presentation of agenda items, it is recommended in omnibus fashion that the Commission adopt the recommendation appearing in the proceeding involving the Commission's Bureau of Investigation and Enforcement versus Erie Transportation Services, Inc. at the bottom of page 7 as well. As the two matters appearing on page 8 through and including the recommendation in the proceeding involving the application of the Reading, Blue Mountain, and Northern Railroad for a new at-grade crossing in Luzerne County.
Do I have a motion to adopt the staff recommendations?
So moved.
Do I have a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Bureau of Technical Utility Services. Again, in omnibus fashion, it is recommended that the Commission adopt the staff recommendations, commencing with that appearing at the top of page 9 in the matter designated Pennsylvania Turnpike Commission involving its application for approval of the replacement of an at-grade crossing where the Norfolk Southern Railroad Company has property in Middlesex Township in Cumberland County. And continuing with the recommendations, the remaining recommendations on pages 9, 10, and 11 through and including the recommendation in the proceeding involving the Pennsylvania Electric Company's letter notification to rearrange certain lines in Warren County, Pennsylvania.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second? Motion by Commissioner Coleman, second by Commissioner Powson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On behalf of the Law Bureau, with regard to matters appearing on page 12, it is recommended that the Commission adopt both recommendations there appearing in the proceedings involving Boomerang Wireless LLC, as well as the matter involving MCI Metro Access Transmission Services, LLC, DBA Verizon Access Transmission.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powson. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Office of Administrative Law Judge, commencing on page 13 of the public meeting agenda. With regard to the first matter, that being the general rate increase proceeding of UGI Utilities, Inc., Gas Division, and ALJ Colwell's recommended decision approving a settlement in that proceeding, there is the motion of Vice Chairman Place, as well as the joint statement that you have, Madam Chairman, with Commissioner Sweet, and a separate statement of Commissioner Sweet.
Do I have a motion to call up this matter for consideration?
So moved.
Do I have a second? Second. Motion by Commissioner Coleman, second by Commissioner Sweet to call up this matter for consideration. And at this point, I will recognize Vice Chairman Place for his motion.
Thank you, Chairman. I'd like my motion entered into the record as if I'd read it in its entirety. Before the Commission is UGI Utilities Incorporated, Gas Division's January 19, 2016 distribution base rate case filing, and the terms and conditions of the joint petition for settlement of all issues by the parties in the proceeding. While I'm supportive of the settlement in this case, I propose a clarification regarding the terms of the agreement. The parties in this case did not identify a specific return on equity for distribution system improvement charge computation purposes. However, Act 11 of 2012 requires that companies using a DISC calculate depreciation using the ROE calculated in the utility's most recent base rate proceeding, or if the proceeding was over 2 years prior, using the rate calculated by the Commission in the most recent quarterly report of the earnings of jurisdictional utilities. Because there is no clear statement of ROE for DISC computation within this base rate proceeding, I recommend that, to the extent applicable, the company use the ROE stipulated in the most recent staff quarterly report. I also want to clarify that on an ongoing forward basis, UGI should update its ROE for DISC purposes consistent with any changes in the ROE in the quarterly report. In addition, parties to rate case proceedings are reminded that in accordance with the Public Utility Code and consistent with our DISC implementation order, it is strongly suggested that rate case settlements include a stipulated ROE for the calculation of the DISC. This stipulation may simply be a reference to use the most recent staff quarterly report. Secondly, UGI proposes to include a combined heat and power program as part of its energy efficiency and conservation program. This program is essentially the only natural gas EE&C program targeted for large customers, rate schedule LFD. The program will target large commercial industrial customers with high thermal and electric loads, such as hospitals, college campuses, and multi-shift industrial customers. Due to the current state of avoided costs, UGI anticipates that it will be difficult to find cost-effective projects that are below 1,000 kW. Previously, the Commission has rejected the inclusion of CHIP programs in natural gas EE&C programs. In general, natural gas EE&C programs are designed to reduce the usage of natural gas. CHIP programs, to the contrary, usually result in higher natural gas usage, but produce an overall reduction in total energy usage. As such, CHIP programs are more akin to market development projects in addition to being energy efficient. Thus, the Commission had rejected CHIP programs in natural gas EE&C programs. However, in this instance, and under the additional conditions below, I recommend support for this proposal. Several unique conditions exist in this case. First, the CHIP program is targeted to LFD customers. This customer segment will fund these programs and receive the benefits. Thus, no other rate classes will be impacted. Secondly, the company has agreed to track these projects separately because the fuel switching program will result in an increase in gas usage that should not be conflated with the savings from the energy efficiency programs. Lastly, it is important for the company to offer programs that may be attractive to this large customer segment and that can enhance the long-term competitiveness of our commercial and industrial sectors. My support for this CHIP program is, however, conditioned as follows. As noted above, CHIP programs are most appropriately categorized as market development projects. The economic tests for market expansion extension vary substantially from the total resource cost test and the program administrator cost test proposed for this EE and C plan. As such, UGI should develop an economic test consistent with the company's new business extension tariff. The economic test will permit the incremental revenue benefits to the company to be compared with the CHIP program costs, including the incentive costs of the program paid by customers. This method will help ensure that CHIP program participants are not being subsidized by non-participants in the long run. Lastly, I wish to make one administrative correction to page 71 of the Administrative Law Judge's recommended decision as identified in my motion. Therefore, I move that 1, the joint petition for settlement be approved, 2, the recommended decision be adopted as modified by this motion, and 3, the Office of Special Assistants prepare an opinion and order consistent with this motion. Thank you.
Thank you. There's a motion by Vice Chairman Place. Is there a second?
Second.
Second by Commissioner Powson. Under discussion for the motion, I recognize Commissioner Sweet. He has a statement, and he has a joint statement.
Thank you, Madam Chair. First, the statement is, again, dealing with staffing issues, and I'd ask that it be placed upon the record. The joint statement is from myself and from the chair, and I will summarize it and ask that the full statement be placed in the record as though I had read it in its entirety. Before the Commission is Administrative Law Judge Susan D. Colwell's recommended decision approving a complete settlement in UGI Utilities, Inc. Gas Division's base rate case. All litigating parties, as well as the Administrative Law Judge, agree that this settlement is in the public interest. Included in UGI's rate case and settlement, among other things, is a voluntary 5-year energy efficiency and conservation plan. We commend UGI and the parties for developing a voluntary plan that will provide customers rebates and incentives for the installation of efficient equipment and the implementation of behavioral measures to reduce energy consumption. Also included in the plan is a separate program providing incentives to commercial and industrial customers for the installation of combined heat and power systems, CHP, as was just discussed by Vice Chair Place. This commission has been a strong proponent of CHP and believes that this program will result in a net total energy decrease for participating customers. Lastly, the settlement in this case includes a 3-year Technology and Development Rider Pilot Program, TED, which was also mentioned. The TED rider allows UGI commercial customers to negotiate their overall distribution charges to help increase access to and expand the use of natural gas. We commend UGI for including a mechanism that provides larger customers more options to obtain natural gas services. Thank you.
Thank you. On the motion, is there a second?
Second.
Excuse me, we already had the second on.
Well, you're
Excuse
consistent.
me. I'm consistent. Is there any further discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended by the motion, is there any objection to taking the previous roll call? Hearing none, the matter passes 5-0.
It is recommended that the Commission adopt ALJ Cheskis's initial decision in the proceeding involving Sherry Kalasnik versus Verizon Pennsylvania LLC.
Is there a motion to adopt the staff recommendation?
So moved.
And is there a second?
Second?
Motion by Commissioner Powson, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
With regard to the complaint proceeding of Terry R. White versus Verizon North LLC, there is the joint motion, Madam Chairman, that you have with Vice Chairman Place.
Is there a motion to bring up this matter for consideration? Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Under discussion, I would recognize Vice Chairman Place for the joint motion.
Thank you, Chairman. We would like our motion placed into the record as if I had read it in its entirety. Before us for disposition is the initial decision of Administrative Law Judge David A. Salapa addressing the formal complaint of Mr. Terry R. White against Verizon North LLC. The initial decision sustains the Verizon North preliminary objections and dismisses the formal complaint. The initial decision essentially states that the Commission lacks jurisdiction over the complainant's complaint. We disagree with the legal premise of this holding because it is not consistent with the statutory directives under Chapter 30 of the Public Utility Code. The Verizon North proceedings suggest that as of March 25th, 2016, it provides digital subscriber line broadband access service to the complainant at a 3 megabits per second download speed. However, available documentation does not permit the disposition of this case with the requisite degree of finality. The Commission has appropriate statutory jurisdiction to properly inquire into matters involving the availability and provisioning of retail broadband access service by local telephone companies, with Chapter 30 broadband deployment commitments and obligations. Verizon North is such a Chapter 30 local telephone company. It has completed its broadband deployment as of December 31st, 2015. It is required to supply retail broadband access services using any technology at the statutorily prescribed minimum download speed of 1.544 megabits per second and upload speed of 128 kilobits per second. It must also provide such services within 10 business days. Thus, the Commission has the necessary jurisdiction to determine whether Verizon North is providing retail broadband access service to the complainant consistent with the applicable Chapter 30 statutory standards. Therefore, we move that, 1, this proceeding be remanded to the Office of Administrative Law Judge for the limited factual determination whether Verizon North LLC is providing retail broadband access service to the complainant consistent with applicable Chapter 30 standards. 2, that the Office of Special Assistance prepare the appropriate order consistent with this motion. And 3, the order be served to all parties of record, the Office of Consumer Advocate, the Office of Small Business Advocate, the Commission's Bureau of Investigation and Enforcement. Thank you.
Thank you. You heard the motion of Vice Chairman Place. Is there a second?
Second.
Second by Commissioner Sweet. Any discussion on the joint motion? Hearing none. All those in favor say aye.
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 Any opposed? The joint motion passes 5-0. Is there any objection to taking the previous roll call on the matter as amended? Hearing none, the motion passes 5-0.
With that concluding the regular agenda, we turn now to the carrying agenda, and it is recommended that the Commission adopt on behalf of the Law Bureau the recommendation with regard to the petition for reconsideration in the Pico Energy Company proceeding there noted.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that does conclude the presentation of agenda items.
Thank you very much. This was a long meeting. We want to thank the staff for all their hard work on all these matters. And with that, the meeting is adjourned.